All right. Hello, everybody. My name is James Rainey. I'm with Rainey & Rainey Elder Law Attorneys. I'm going to visit with you today about wills and trusts, the differences between the two, and some considerations that you should think of when you're considering a will and or a trust or both. We have some slides I'm going to go through today as a part of our presentation. So I'm going to share the screen right now so that you guys will be able to see the slides as we talk about them. All right. So wills versus trusts, what's the difference? What do they do? When do you use them? What are some important considerations that you need to know about them? Let's visit about that. Before we talk about a will or a trust, I do want us to understand that there are distinctions in property here in Texas. Texas is presumes that everything a couple owns is community property. So if you're married, the presumption is what you and your spouse own, you own jointly together as community property. That is the presumption. That means you're 50-50 owners, tenants in common or co-tenants, but you own it together as community property. If you don't own it as community property, then it could potentially be considered separate property to one of the spouses. And we're going to go over some ways that you have separate property in a minute. Also in Texas, it's important for us to know and understand probate property versus non-probate property. But in short, your will controls assets that are probate assets. Everything else is non-probate property, meaning that it's going to pass or be transferred to somebody on your death because you've made arrangements for that to happen outside of a probate and outside of the will. That's a non-probate property. So looking at property, we need to understand that separate property, the four most common ways you have separate property in Texas are as follows. First, if you own something before you got married and you kept it separate, then it is separate property. A good example I like to use is if I had owned $50,000 in my name in a bank account in a bank of my choice before I got married. I then married my wife, Elisa. 25 years later, if I've kept that bank account separate in my name only, that $25,000 or whatever amount was in it is still my separate property. Now the interest earned might be community property, but the original balance when we got married remains my separate property. I kept it separate and it stayed in my name and I owned it before I got married. Another common way to have separate property in Texas is from a gift. So if my mother gifts property to me, whether it be a car or a land or a house or money, if I get that property and keep it separate, it's my separate property. The third way that's very common is inheritance. Inheritance can trip people up a lot because what's very common is to have a married couple that's been married for many years or possibly even a second marriage. And then one of the couple's parents die and that spouse inherits land, a farm, money, or a ranch, and that is their separate property. So why is that important? Because if we don't have a will or a trust that disposes of that property on our death, it doesn't automatically go to our spouse. And we'll discuss that more in a moment. So inheritance that's kept separate is separate property of the spouse. And finally, probably the fourth most common way that we have separate property in Texas is through a prenuptial agreement or a post-nuptial agreement, a property agreement where spouses agree and partition property and say, hey, what's mine is mine, what's yours is yours. We'll agree to keep it separate. Any interest from my property is my separate property. Any interest from your property is your separate property. Those are what we call partition agreements, prenuptial or marital agreements. They establish separate property rights in Texas. So why is this important? Because who gets the property that we own when we die is determined according to the type of property it is and what our relationships are with others. So when I die, if I don't have a will or a trust or other arrangements in place, my property does not necessarily automatically go to my wife. That is an assumption that a lot of people make that is not true. We have 5 or 6 statutes here in the state of Texas called the Laws of Descent and Distribution, and they all work together, and they all determine who gets our property as our heir if we don't determine it through a will, a trust, or another arrangement. So, for example, if I'm married and I die, if I have a traditional marriage, meaning me and my wife have been married forever, the only children we have are jointly from our marriage. There's no children from a previous relationship. It's not a second marriage. It's just us two, our children. When I die, if I don't have a will or a trust or something in place arranging for the disposition of my property, my wife will inherit my community property. She inherits all of the community property that we own together. She gets my interest in that community property. However, if I owned separate property, like we talked about a few minutes ago, if I owned something that had been gifted to me or that I inherited, it does not go to my wife. It gets split between my wife and between my children. And how it gets split depends on whether or not it's land or money or furniture or cars. It all makes a difference how it gets split between my wife and my children. And if I've had children from a previous marriage, the children from a previous marriage or a previous relationship are included in that division of property. So it doesn't just all go to my spouse or children. It might go to both. It just depends on whether or not it's a traditional marriage, a second marriage. Even if I'm married and my wife and I have been married for 20 years, we have 2 children together, but I had children prior to that. Maybe in high school, I'd accidentally had a child, or maybe I was married for 4 or 5 years, had a child with my first wife. That didn't work out, got remarried, have been happily married, but I have 3 children. Well, then the community property is not all inherited by my wife. It's split equally between my wife. She keeps her 1/2. The rest goes to my 3 children to be divided equally. So we need to determine who's going to get our property while we're alive, while we're healthy. And we usually do that through a will or a trust or some type of other arrangement. So it's very, very important that we make our planning and arrange for who gets our property when we die according to how we want it to be disposed of. As we visited about earlier, non-probate property is property for which there is a contractual arrangement made such that it will pass to a named beneficiary when I die. So a most common example of that would be life insurance. When I purchase life insurance, I tell the life insurance company, when I die, I want you to take all of the money that's life insurance proceeds and deliver it to the following person or people who are my named beneficiaries. So that is a non-probate asset because it has been arranged to be delivered to somebody automatically when I die. Another common example, retirement and IRA benefits. Those also transfer usually on death by a contractual arrangement. Not necessarily so, but often people name a beneficiary on their retirement and IRA benefits. If they don't, then it goes through the will. Property held in trust is usually, again, a non-probate asset because usually if we have a trust, we'll state in our trust and we'll give instructions to a successor trustee what to do with the property owned by the trust when we die. So there's an arrangement made for that property to continue to be managed in the trust or to be delivered to somebody when I die, and therefore it's a non-probate asset. Also, joint tenants with right or survivorship is a non-probate asset. If my wife and I have a checking account together and it's a joint tenant with right or survivorship, then when one of us dies, the other one automatically owns everything in it. And it's just an automatic ownership change. So that brings us to a will. What is the purpose for a will? Several things that we want to accomplish when we draft a will. We're going to name our beneficiaries. We get to choose who gets our property and under what terms and conditions they get our property when we die. And that's a very broad decision. Really, I get to decide, or you get to decide who gets your property when you make your will. An example, I recently worked on a case where a gentleman out in Bosque County died, had a $1.5 million ranch that he left to his mistress. That's right, his mistress. He had a relationship with this lady. He and his wife separated. He continued to see this lady. Then when he died, he left her the ranch. Not to his children, not to the lady he was still married to, but to his mistress. She inherited the whole ranch. Now, he left funds in different bank accounts to his children, but he left the ranch to his girlfriend. And his children acknowledged that he was mentally competent. He knew what he was doing. There was really no grounds to challenge that because he owned that ranch. It was his separate property. So you get to choose who gets your property when you do your will. You get to name an executor. An executor is the person who has to be approved by the court, who's going to step into your shoes, collect all of your monies, your assets, negotiate your debts, pay off your debts, and then deliver the property pursuant to the terms of the will to your beneficiaries. In your will, if you have minor children, you can name the guardian in case something happens to you. Who do you want to be responsible for and to take care of your children in the event you're killed in an accident? You can also allocate debts and taxes. You can deal with federal estate taxes if you have a very large estate. And if you have a right to make a power of appointment due to some estate planning that your parents or another family may have made, you could exercise that in your will. So a last will and testament, once it's been drafted, it has to have been signed by you. It has to have two witnesses who were present with you when you signed it, who witnessed you sign it, and signed that they saw you sign it, and that you seem to be of sound mind, all at the same time. And if it's self-proved, that means it was sworn to by you and by the witnesses as well. Then if it meets those requirements, it can be probated. One thing to understand is your last will and testament has to go through probate in order to be considered a valid will. There's a lot of confusion. I get a lot of phone calls, or I have a lot of appointments with folks. And, 3 years ago, mom died, had a will, but now the bank won't give them the money, or now there's a complaint because the title company doesn't recognize that they inherited the house because the will said they inherited the house. But that's because the will was not probated. And so if you don't probate the will, the terms of the will does not control over the assets of the estate. It's going to go according to those descent and distribution statutes I mentioned earlier. So you have to probate the will. And what happens when you probate a will? You file it with the court, and then you ask the court to appoint the executor named in the will. The judge waives a bond for the executor because that's usually what the will provides for. And then once the executor is officially appointed by the judge, they're given what's called letters of testamentary. But they're not really letters in the sense that we often think about letters. They are a certificate issued by the clerk of the court, publicly notifying anybody who needs to know that the judge has appointed a certain person as the executor of your estate. That letter, that certificate, is what gives the executor the power to access money, sign the estate's name, and transfer property. So the executor then gathers all the assets, pays and negotiates the debts, and then delivers the assets pursuant to the terms of the will. That is not a very complicated or expensive process in Texas for most estates. For your traditional families that own a house, some cars, investment accounts, savings accounts, maybe a second piece of property somewhere, that this process, as long as you have a valid written will, is not very terribly expensive, is not terribly complex, but it is out there and it does have to be followed. Now, I do get questions a lot. What about a trust? Can I do a trust? What is a trust? Well, a purpose of a trust is very similar to a will, and it's a little bit more. It's a little broader, right? It can be used to manage and preserve the estate. It can also be used to reduce taxes, to transfer assets when we die, to avoid probate, and sometimes, depending on how it's drafted, it can protect assets from the estate. Now, there's two different kinds of trust. There's an inter vivos or inter vivos trust, and then a testamentary trust. The inter vivos trust is created during our lifetime, and it can be revocable or irrevocable, however we decide to draft it. The most common type of an inter vivos trust would be a family living trust, You often will hear news magazines talk about it, like MSNBC or CNBC or something. You'll hear experts or financial advisors talk about a living trust or a family trust. Those are usually inter vivos trusts. They're trusts that you set up while you're alive, and you often use them while you're alive. So those are inter vivos trusts. A testamentary trust is a trust that we create in our will. So we draft the will, we decide who's going to get our property, how they're going to get our property, and part of that, we may decide somebody's going to get property in a trust, and that trust is created as a part of our will. The will gets probated, that creates the trust. That's called a testamentary trust, and they're usually irrevocable on death. The inter vivos trust is made now while we're alive, usually for our benefit. When we create a trust, our family living trust that we're going to use now, we still have to make a will, because often when we create a family trust or a living trust, what we have to do is transfer our house, transfer our car, transfer our bank account, transfer our savings and brokerage accounts, transfer our four-wheeler. Everything we own gets transferred into the name of the trust. And then the trust owns it, and the trust has instructions inside the trust what to do with the property when we die, right? Usually we instruct the trust to do whatever we want to do with our trust money and our trust fund and our trust property. We are usually the trustee while we're alive. We manage the trust for ourselves, and we have an instruction that tells ourselves, you can do whatever you want with the trust property to take care of yourself. And then in the trust document, we'll have instructions to somebody who takes our place when we die. That person's called the successor trustee, and we'll have instructions saying, hey, when you take over for me when I die, I want you to do the following. And then we give them very specific instructions on what to do with the property when we die. But what often happens is when we create this trust and we transfer everything into it, later we might sell our house and buy a new house. But when we buy that new house, we might not put it into the trust. We leave it in our personal name over here. Or we might buy a vehicle and not put it in the name of the trust. Might forget about the trust or open a new bank account and not put it in the name of the trust. So when we die, they are now probate assets. What the trust owns is a non-probate asset, but these other items that we acquired later, not inside the trust, still have to be taken care of when we die. So we still need a will, and usually we use what's called a pour-over will. The will says anything I own when I die is to be distributed to and delivered to the trust. So we probate the will, we move those assets into the trust, then the trustee has instructions on what to do with them. That's usually the way that works. Another type of trust that we see a lot for inter vivos while we're still alive are special needs trusts for beneficiaries with disabilities. So if we have children or siblings that have some sort of disability that need public benefits, we might create a trust now that we can put money into, or that other family members can contribute money to, for the benefit of our disabled child or brother or sister or family member. And that will not disqualify that person, that disabled child, from getting public benefits. So we use those a lot. So we've talked about this, the typical setup, the revocable living trust. Inside the trust, we're going to name a trustee. We're going to name somebody to take over when we die, called the successor trustee. We're going to name beneficiaries, and we're going to give instructions to the trustees. We have a pour-over will. And then when we're done, we're going to make sure all of our assets are transferred into the trust, and we'll manage the trusts as we decide until both spouses die, when the successor trustee takes over. Let's talk about testamentary trusts. Those are drafted as a part of our will. They become effective upon our death once the will is probated. And there are 4 types of testamentary trusts that we see a lot of in our practice. The first one is a special needs trust for children with disabilities. So like I talked about a few minutes ago, we can establish a trust now while we're alive that we use to benefit somebody who's disabled and might need public benefits. Sometimes we don't establish that trust while we're alive. We just wait until we're going to pass, and we have our will create that trust. And if I have 2 children, one that's doesn't have any troubles, the other one that does have disabilities and may need public benefits, I might leave one half to my one child and the other half to my other child in a special needs trust. And I'll create the special needs trust as a part of the will. I'll name the trustee who's going to manage the money for my disabled child, all in my will, and it all gets set up when I die. Because while I'm alive, I can take care of my child without the need for a special needs trust. And so we just do it that way. Another common way is to do a special needs trust for a spouse. This is an advanced planning technique where we do it when we're concerned that the surviving spouse may need nursing home care at some point, and we want to protect and shield at least one half of the assets from future nursing home costs. So what we do is we create in the spouse's will, each spouse creates a contingent special needs trust that says, I leave everything to my husband, or I leave everything to my wife when I die. But if my executor determines that my wife or husband is likely to need nursing home care at some point soon, then my executor may take my one half of the community property and anything that I own that's separate property and deliver it to a special needs trust for the benefit of my spouse. When my spouse dies, then whatever's left over goes to my children. All right? By doing that, when I die, one half of all the property we own goes into this special needs trust, and it's immediately shielded and protected from nursing home costs, which will allow my surviving spouse, my wife, to later qualify for Medicaid to pay for her nursing home care once she uses up her one half of the assets. Once she does the spend down for her one half of the assets, my one half are shielded and protected and don't have to be spent down. And if she never needs nursing home care, the trust still supports her and supplements her lifestyle and helps her pay for her bills. And whatever's left over goes to the children. It's a very, very powerful tool. Another type of trust that we see and we do a lot is where we set up a trust for the surviving spouse, maybe not a special needs trust, but just a traditional trust, and say, when I die, everything goes into a trust for my wife. Then when she dies, whatever's left goes into onto the kids that we have together. Now, I do that a lot, and we see that a lot because we often have cases where husband or wife is concerned that once they die, their surviving partner, their husband or their wife, is going to remarry. And if they remarry and they fall in love with a second person, they may want to leave everything to that second spouse instead of leaving everything to the children of the first couple. And so this makes sure that property gets protected for the children of the couple, even if the surviving spouse gets remarried. And then fourth, we do a lot of trusts for children. So mom and dad come in to see us, the husband and wife, they want to leave something for their children, or they want to leave it all to their children equally, but they might have one child who they say is a spendthrift. The minute they get money, it's going to be spent. Or the child's spouse might be the spendthrift, right? Or they may just not like the child's spouse. They think that the child's spouse is mean or exerts undue influence on their child, whatever the case might be, and they don't want their child to get their money and it be wasted. So we put that money into a trust with instructions to the trustee to deliver it in certain intervals or to use it for certain purposes for the benefit of the child. So we do a lot of that as well. Now, those are all testamentary trusts. They're part of the will, and the will has to be probated to effectuate those trusts when we die. So what's better for us in Texas, a will or a trust? Now, it just kind of depends on what our goal is when we die, right? Do we want a trust where we can try to control more strings and determine more who gets the property when? Do we want it to go outright when we die? Do we want to avoid probate or all considerations to determine whether or not we want to create a inter vivos family trust now, or a testamentary trust as a part of our will? Or do we just want a will that leaves everything outright to our spouse and kids? Again, it also depends on what our needs are. Do we have special needs children? Do we have a concern? Are we older that our surviving spouse might need nursing home care and we want to preserve assets for children? All of that has to get weighed into what's the best approach. But I will tell you, the cost in Texas to do a revocable living trust and all the documents to go with it is kind of expensive, but not that much more or less than what it would be if you had to probate a will. So in Texas, having a trust versus probating a good, valid will, the cost really isn't that much different. So that's not really a consideration on whether or not to do a trust. The consideration is, what do we want to accomplish? What's the best way to get it done? When we die, how do we want our property distributed? How do we want to manage our property while we're alive as well? That's a very important detail. And so there are advantages and disadvantages to having the trust or not having the trust. I hope that this has been helpful to you, trying to understand a little bit of what the differences are between the two. If we can help you at any time, please give us a call. Check out our website, our YouTube channel, our Facebook page for more information, and we'll be happy to go over any of this in more detail. Thanks again. Again, raineyandraney.com is our website, and I'm James Rainey, and our phone number is 254-752-8644.